All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV21-0641, Co. versus Maricopa Meadows. These proceedings, counsel, are being video and audio recorded, so we ask that counsel please identify yourselves and your client at the beginning of your argument. And I believe we're probably still streaming via YouTube live. I think we still are.
We are.
All right. So be aware of that. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and we have conferenced the matter. So at this point, counsel, you may proceed.
Thank you, Your Honor. May it please the court and good morning. My name is David Wood and with me here is Robert Connolly. We are from the DeSalis Law Group and we represent the appellant plaintiff Daniel Coe. The issue before this court is whether Arizona does or should fully immunize a hit letter sent by an HOA to a public employer about private criticisms of that HOA when that public employer has no jurisdiction over the conduct, has no applicable policy or law regarding that conduct, and could potentially, if those other two are wrong, hold a completely non-judicial proceeding where absolute immunity is reserved for certain statements preliminary to a judicial proceeding. So this court can and should reverse on any number of bases. The large policy base is that absolute immunity or absolute privilege is reserved for rare situations that are of vital public interest. Or this court has used a little bit of differing language, but of great public interest, vital public interest.
Well, is it the subject matter that needs to be of vital public interest, or is it the structure of the proceedings themselves?
It's both. The structure of the proceedings, which would be a judicial proceeding where the public has entrusted the truth-finding function to take place.
So major statements are privileged, but minor statements aren't?
So it's not just a major-minor distinction. If it relates to a judicial proceeding, that is considered that can be a vital public interest. If it's related to potentially like a government review or a government investigation, that's where you do look at the subject matter to determine, is it vital, or this court has talked about an intermediate interest, which would be a qualified privilege.
Okay. And so what's your best case suggesting that the privilege is anything but absolute?
Well, a few things.
I mean, do you have authority for that proposition? Do you have a case that says, you mentioned an Arizona case saying an intermediate standard. Do you have a case saying that we should have a qualified privilege for this kind of statement, but an absolute privilege for others? The
most analogous of those, Your Honor, if you can, I apologize for my scrolling. I made a table for this. The most analogous would be Lewis versus Oliver, which applied to hotline complaints about government employees, where this court found that it would be a qualified proceeding, finding that it was not a judicial proceeding and it was instead governed as a general complaint to a public official, which under the restatement is under the listing of qualified privileges. Okay. So that would be the most analogous if we're looking for just a case to compare. But if you go through the factors for absolute privilege, this matter will not qualify because this is a letter with not one iota of substance about supposedly Mr. Coe's continued statements, and instead just an attribution of alleged malicious intent. So when you look at that, it doesn't have the what, the when, the why, and you can see at the bottom of the last letter where it's a request to essentially have the United States military, which again doesn't have jurisdiction over this, to essentially work with Mr. Coe to stop him from talking about the HOA. So,
well, let's assume for purposes of argument that this statement was, or this complaint was really not made in good faith, was a way of harassing your client.
Yeah.
Okay, let's just assume that that's a fact.
okay.
The question becomes then just a pure question of law, because if this is an absolute privilege, it doesn't matter if the statements were made in bad faith. And you can understand why policy evolved that way, right? Because we don't want people calling 911 and then getting sued for defamation if their report happens to be wrong. We don't want people afraid to report to law enforcement or investigative bodies charges that they think have merit, because there might be retribution years later depending on the outcome of the proceeding. Arizona public policy has just cut that off. So your job really is to find a reason that law doesn't apply to you. We don't really have to talk about whether the statement was in bad faith, because we'll assume it.
Okay, and I appreciate that, Your Honor. So let's talk about what you've talked about, the Arizona policy. The Arizona policy was largely adopted from the restatement for statements preliminary to a judicial proceeding. And that's where the guidance from this court in Burns versus Davis, and a case that I didn't cite in my brief, is a party named Young, Y-E-U-N-G, look to. That policy applies if there are judicial functions in the contemplated proceeding. And the reason, I'm sorry.
I guess I would just say, to move things along, the argument would be judicial proceedings could have been actually spawned by this complaint. In theory, they weren't. They probably were correctly rejected. But structurally, a complaint like this could have implicated misconduct that could have led to judicial or quasi-judicial disciplinary proceedings. So why isn't that enough?
Well, because the United States military had no jurisdiction.
The United States military had jurisdiction over this gentleman's conduct.
No, only on duty.
Well, okay. What kind of jurisdiction does the state bar have over you?
When I'm acting in the capacity of a lawyer?
Well, if on the weekend you go and rob a Circle K and I call 911 about it, or no, forget 911. I don't like calling 911. I'm going to call the state bar and say you're robbing Circle K's on the weekend, not in your capacity as a lawyer, but still it raises some ER 8.4 issues. And keep in mind, this is a total false hypothetical. If I make that report, am I absolutely immune or only qualifiedly privileged?
You're absolutely immune because there is a directly on point policy under the rules of professional conduct, which are if a lawyer commits an offense which impugns their honesty or their fitness as an attorney, yes, that report qualifies as absolutely immune. But it also qualifies as absolutely immune because, after I rob that Circle K, hypothetically, the state bar, I get a formal hearing. I get neutral fact finders, I get discovery, I get cross-examination. The state bar is put to a clear and convincing evidence standard. I get compulsory process. Everybody's put under the oath. In either the Arizona National Guard or the U.S. National Guard, they can be forced into a non-judicial proceeding, which is simply a meeting with a supervisor. No compulsory process, no cross-examination.
Well, that's one avenue it could take, but if the military were to deem this serious enough, it could evolve into presumably a full court-martial.
And that would be a new direction for this court. This court has blessed absolute immunity for state bar proceedings, which I just outlined, and for reports to the police where if that report goes somewhere, the target of those comments, they get a criminal proceeding. They get neutral fact finders or a neutral fact finder.
I'm sorry. I don't know if I caught your response to Judge Swan's question. So do you agree that it could have gone by way of a judicial proceeding, though it wasn't in this case?
No, because
there's absolutely no way in which it could have turned into a judicial proceeding?
No, because the United States military only had authority over Mr. Coe when he was called into federal service. They sent this to the United States military asking for an investigation under federal Department of Defense policy, which hadn't existed for 30 years, by the way. So, no, there was no jurisdiction for the United States military, and there was no policy applicable. So, no, there could not have been a judicial proceeding. In addition to, when we look at those rare cases for absolute privilege, the only proceeding available is a judicial proceeding, not maybe. It's a criminal trial or a state bar formal hearing. That's where this court has talked about an absolute privilege. And since we're talking a lot about reports to the police, I wanted to go through a little bit of the actual holding in Ledvina, where this court did not simply say it's a judicial proceeding. This court said we've engaged in a careful balance, and because we have a victim's constitutional bill of rights, we believe an absolute privilege should apply. In addition, there's a contempt protection for the target of this. There's a perjury protection for the target of this. So that was the very carefully balanced finding that a report to the police should be absolutely immune. Here we have an HOA who's trying to dig up policies and not actually seeing that they don't exist anymore, sending them to the wrong employer, although that is the employer of Mr. Coe sometimes, which definitely hurts him in the defamation context, for no crime. In addition, I did, since there was a discussion in the answering brief of the California case Halberg that was cited by Ledvina, I would point out that that California case relied on a privilege statute, and it's no longer good law for the proposition that was even cited in Ledvina. That was California Civil Code 47. 2 years ago, California actually reduced reports to police to qualified privilege and said they're not absolutely privileged anymore. So even some of the basis for Ledvina, and I'm not asking you to disagree with Ledvina, you don't need to, but
and
even some of the basis.
We don't need to adopt California's approach to privilege.
What's that?
We don't need to adopt California.
No.
Arguably, we should not adopt California.
Nor need you. In this case, you just go through the factors for privilege, and you can pick bases to reject this. Was this hit letter something that was so vital to the public interest that it should be absolute immune? No, because it's just stop criticizing us at neighborhood meetings or online about who should be on the board of directors. Was this for something that in good faith could be considered preliminary to an imminent judicial proceeding? No, because they can't hold one. But also, even if we start switching to saying that we should look at the Arizona Code of Military Justice, even there, under Arizona statute, Mr. Coe could be forced into a non-judicial proceeding without the protections that are required for the balancing to give an absolute privilege. And bear in mind...
Is that a suggestion that the military process is not significant enough to trigger an absolute privilege, or that it's not sufficiently protective of due process rights?
It's not sufficiently protective of the judicial functions that this court has found required. So I hesitate to say due process because that is not the language of its use.
Because military justice is different, right? There are certain rights that we are all accustomed to in the civil world that don't apply in the military world, that's not a basis for a distinction, is it?
Well,
I mean, let's assume we were talking about a very serious offense.
okay.
That something for which somebody could be court-martialed, dishonorably discharged, and perhaps incarcerated for. That judicial proceeding or quasi-judicial proceeding would look different from a criminal case in federal or state court. But nonetheless, the complaint that gave rise to it would be absolutely privileged, no?
As long as those judicial functions were existing there, they don't have to be, marry up 100% apples to apples. The point that I'm making with a non-judicial proceeding is you get none of the protections. You don't get cross-examination. You don't get compulsory process. You get just whatever your supervisor says I think is warranted in this situation. So I guess I appreciate your question, Judge Vaughn, but I don't think that you need to go to whether each factor needs to marry up.
What if the complaint is for sexual harassment that occurs off-duty? And a victim complainant reports that in the same manner as the HOA did here. Would you say that that's absolutely or qualifiedly privileged?
If it was, you would look at all of the circumstances to see if it was to initiate a judicial proceeding or whether it fell under one of the other potential privilege
Well, I don't think anyone in this room fully understands the military discipline process, so I don't think we can reasonably expect a random member of the public to understand the procedural nuances. The question is, does our public policy that underlines the absolute privilege protect someone in an absolutely privileged way for reporting sexual harassment?
Well, I can tell you, and I don't think it's cited in either brief, there is a case from this court about 40 years ago that said, no, it's qualified. And I apologize that I don't have that off the top of my head because that was in the private employer context. But the court did find.
If we're in the government employment context, where the disciplinary process would have some due process associated with it, right? I mean, it might look different in the military, but it still exists.
Well, and that gets very difficult because then we would have to go agency to agency. I represent officers in their public hearings, and a lot of those protections don't exist in those hearings, and we would have to look at it agency by agency.
Due process protections.
Right.
Right, but is a complaint against an officer qualifiedly privileged?
A complaint against an officer most likely is qualifiedly privileged.
What's
but again,
your authority for that?
Because it would be going back to Lewis, where generally complaints to a supervising public official are considered qualifiedly privileged.
Okay.
So, and I have about 3 minutes left, so I'll reserve that time.
So before you
sorry.
start, I'm trying to understand your position. So
Okay.
your position is absolute immunity doesn't apply here because the complaint wouldn't initiate or result in a judicial proceeding, even if the HOA believed it would. And the military has no jurisdiction over Coe's conduct here because he was off duty.
Correct.
Okay.
I have more points too, but I'll bring them up in rebuttal. Thank
All right,
you.
thank you, counsel.
Good morning. May it please the court. My name is Christopher Bork. I'm here representing defendant appellee, the Maricopa Meadows Homeowners Association. Obviously, there's been some confusion about the jurisdiction of the military over Mr. Coe. And that goes back to what you said, Judge Swan, about none of us in this room really have much knowledge of military law. So, I mean, the confusion began when Maricopa Meadows attorney sent this letter to the Arizona National Guard and cited essentially federal statutes and Department of Defense directives. But that doesn't mean because they cited the wrong information that the privilege does not apply in this situation. There is an equivalent state legal system, the Arizona Code of, Uniform Code of, ACMG, Arizona Code of Military Justice, that applied to Mr. Coe as a full-time member of the Arizona National Guard. And because he had enlisted in a branch of the military, even though it's located in the state, there were higher expectations upon him that don't apply to ordinary civilians. They expected a higher standard of conduct from him.
Well, Lewis v. Oliver seems to be where the rubber meets the road in this case. And this case either falls under Lewis or it falls closer to Green Acres and its progeny. So if the argument is that it falls closer to Lewis because really this complaint at best could have provoked some sort of informal administrative response, that's a fairly compelling argument unless you can enlighten us as to Arizona military justice and say, no, this opened the door to a full-blown judicial hearing with traditional due process protections.
Well, I think even in the civil and criminal system that applies to civilians, there are always levels of prosecution or levels of the way the prosecutors and the courts address these things. And
sure,
the same thing occurs with the state bar.
Triggered, right? I think everyone would agree that a complaint that results in a judicial proceeding for a petty offense would get the absolute privilege. It's not a matter of severity. It's a matter of what process is about to be invoked by the complaint. And so if the process is judicial, there's an absolute privilege. If the process is legislative, strangely enough, where due process really isn't a concern, then there's also an absolute privilege. But if we're talking about an executive administrative function, there is some doubt. So the question is, what is the most expansive type of proceeding that could have been triggered by this complaint?
A judicial proceeding, a court-martial with all the protections that are provided to somebody under a court-martial. Assistance of counsel.
I'm guessing you didn't expect that a court-martial was likely to result from this HOA dispute. Is this the type of conduct that is even cognizable by court-martial, or is it limited to a more administrative type of review?
I don't think the military justice system really states that, at least in the code itself. I think those determinations are made once a complaint is filed with the appropriate officials in the military system.
So there's no severity threshold for due process type proceedings as opposed to administrative?
Well, not that I've seen in looking through the Arizona Code of Military Justice. It seems to me that, some things you can make some obvious assumptions. If military personnel is distributing secrets to an enemy, that's obviously pretty serious. There are other things that are moderately serious. There are other things that are maybe somewhat minor. But the thing is, when the association made this complaint, they had no idea how the military would take this or process this. And that's really the same in, for example, the state bar situation. Someone can make a complaint to the state bar, and it will be screened by somebody at the state bar who will decide, no, we don't need to send this to a formal proceeding. We'll have them take some CLE, and that will take care of it. I've seen that happen, certainly. I assume the same thing with legal document preparers, like in the cases we have. In the criminal court system applicable to civilians, sometimes the prosecutor decides, I don't have enough evidence, I'm not going to prosecute. Sometimes they decide, I've got some evidence, but it would be better to send this person to diversion, make them take an anger management class, make them take a drug rehabilitation class and go through some process like that, rather than going through the judicial process. And I think the same thing applies here in the military system. A commanding officer can look at this offense and decide, maybe I just need to counsel this guy and tell him to stop doing what he's doing. Maybe they need to look into it further, and they look at the evidence and see that he's acted badly, and they kick it over into the judicial system. And at that point, then, he has those protections of the judicial system. It's definitely a judicial proceeding. But nobody knows that when they make the complaint, and the idea that their immunity is going to depend on how the court system, the agency, in this case the military justice system, deals with that, it can't depend on that, because that would have an adverse effect on people reporting things that they thought were potentially violations of the law. And so what we have here is a situation where the association knew this gentleman, Mr. Coe, was a member of the National Guard. They had a right to expect better conduct from him than they might have expected from a civilian. And that, I think that seems somewhat clear from the military documents that we have cited in the brief, that more is expected of military members. They're supposed to be courteous and polite to the civilians.
That might go to the military's jurisdiction. It's a real stretch for me to imagine that the HOA was trying to make sure that our military was straightened out to the best extent possible. This was a political battle over the most petty form of local politics, and a report was made really to reframe the debate, not to address a problem with the functioning of the American military. Would you agree?
Well, I don't think we know that for sure, because the record is so sparse.
Do you think it's possible that this was actually, that the HOA was concerned that the military was going to
Well, they may not have been
serious
concerned
harm?
about the military, but they certainly could have been concerned about the seriousness of the conduct, because there are representations in the initial letters that say that Mr. Coe was posting things online that were false about members of the board, and it was leading to threats of violence against board members. That is potentially serious, and that Mr. Coe was encouraging racial discrimination against a black manager of the association, and the belief that he was going to try to get that person fired because of the color of their skin. So those are potentially serious things, but we don't know the details because the record is what it is. Now, I would say yes, maybe they realized he was a member of the military, and they said this is another avenue where we can get this corrected, because he's supposed to behave better than some civilian who can go about doing these things without any punitive sanction brought against them. But as members of the public, they had a right to expect better conduct from Mr. Coe and express that to the National Guard if they thought that he was in violation. And certainly, if someone is posting false information that's leading to threats, is posting information or making comments that are racially discriminatory, that adversely affects the National Guard and is potentially subject to sanction. But whatever they knew, and of course their attorney is the one acting on their behalf and making these decisions, I guess, with their consent, he probably gives them the advice that this is a good route to go because he is a member of the military and he is subject to this law. So in any event...
Counsel, in the Ledvina case, this court said that absolute privilege is reserved for situations to encourage free and unhindered communications to law enforcement authorities where it's necessary to facilitate the investigation and prosecution of crimes. So it really seems to focus on crimes. Now, what you're describing occurring here does seem more analogous to a report of conduct, and you've used the word conduct that maybe would reflect poorly on the military. So how do you respond to that?
Well, conduct that reflects adversely on the military is considered a military crime. Now, again, the severity depends upon what exactly was done, but people can be court-martialed for engaging in conduct that is adverse to the military. We cited the case of the Navy CPO who cross-dressed. In the civilian world, that would not be a problem for anybody. You can't get arrested for that in most cases. But in the military situation, that chief petty officer was court-martialed and punished seriously because of his actions. That was a military crime. And so if the Arizona National Guard looked at this and said, you know, this is bad that somebody is engaging in this racially discriminatory conduct, who is making false statements about people, that's potentially a military crime subject to various sanctions. But again, you know, we don't know how that would have come out. And certainly, even in the civilian system, the same kind of thing happens. The prosecutor has discretion to say this is not, yeah, it's criminal, but it's not serious enough that we're going to take this to trial and try to convict this person.
Do you have a legal definition that applies to the conduct complained of that could theoretically constitute a military crime? Do you have a statute or a...
Well, ARS 261134 talks about conduct that brings discredit upon the National Guard. And it's a broad category, and it can be applied to probably any number of things that would affect the way the civilians who are interacting with a Guard member view the National Guard. So in this situation, if people see that Mr. Coe is spreading false statements, if he is making racially discriminatory statements or participating in that, people who know he's a member of the Guard are going to say, you know, I think less of the Guard because of this, or at least potentially could say, think less of the Guard because of this situation. And again, I mean, you know, the cross-dressing situation is an example that may not, in this day and age, offend anybody who saw this Navy member doing this, but the sense of it was, in the military, this is just not something you do because it reflects badly upon the military, and we can punish you for that.
Well, 261134 would seem in its own rather archaic phrasing to support what you're saying. I'd be interested in hearing what your colleague has to say about this in a few minutes.
I'm sorry, what was that?
Be interested to hear what your colleagues have to say about this in a few minutes.
Okay.
Because I'm looking at 1134, and I take your point.
Right. So, I guess the point is that this is a military judicial system. It is a judicial proceeding. What the association was attempting to do when its lawyer sent the letter was initiate a judicial proceeding. And again, we don't know how far along this judicial process it could have gone because that's just not in the record at this point. And they were also attempting to start a judicial proceeding. They were also attempting to report what they envisioned to be a criminal offense in the military justice system and asking the military justice system to investigate this and decide whether Mr. Coe was in violation. So because the nature of this potentially could lead to a judicial process, the privilege should apply here just like it applies in the court system. It applies in the state bar situation when people make complaints to the state bar. So the privilege should be absolute without regard to whether the complaint was made in good faith and without regard to the motive of the speakers. And I would also point out that, part of the confusion here is that Mr. Coe is raising new issues on appeal that he could have addressed in the trial court. He knew, for example, that the lawyers for the association had cited this Department of Defense directive, but he never mentioned in his response in the trial court that the Defense Department directive did not apply to him. He never argued that the military justice system didn't apply to him. Those are all arguments that he waited until the appeal to bring up. And this, if those issues are of any significance, they could have been corrected by the trial court. I don't know that they are, because whether you're under the federal system or under the state system, that's really a question of law. And I think we all probably know now that it's the state system that applies, and it essentially follows the same basic structure as the federal Uniform Code of Military Justice. So I don't have anything more to add. Unless you have any additional questions, I will sit down.
All right, thank you, Counsel.
Thank you, Your Honors.
Thank you, and Judge Swan, I'll go out of order and address what you suggested.
1134?
Yes.
Okay, great.
So what you can see there is what the HOA was intending to do. Take the most generic, vague idea of military authority to silence somebody exercising their First Amendment rights.
But counsel,
Yes.
so the statute, 261134, says it covers all conduct of a nature to bring discredit on the National Guard. I'll skip over a little bit. Shall be taken cognizance by a general, special, or summary court-martial according to the nature and degree of the offense, and shall be punished at the discretion of that court. Okay. How does that not contemplate a judicial proceeding for conduct that brings discredit on the National Guard?
Well, I would say that the issue there is that the HOA has said that there was a specific policy applicable to Mr. Coe, and that would get into the potential legal violations that the Arizona National Guard published a policy saying, we're only giving you guides for your private online behavior, and we are only issuing prohibitions for your on-duty online behavior. So that's standard canon, which is if you have a specific policy, that is what governs as opposed to a general.
Online behavior is it evolves a lot more quickly than the law. And so when you have a catch-all that talks about conduct bringing discredit on the National Guard, the fact that somebody may have come up with an approach to online behavior that doesn't directly offend a published policy doesn't necessarily mean it doesn't offend this more general statute, right?
I would disagree and say that it does, because it is specific guidance to Mr. Coe in his conduct as a member of the Arizona National Guard to then turn around and say that that statute applies. But
then it preempts the statute?
It gives direction to the enforcement of the statute.
It narrows the applicability from all conduct to the specific conduct.
In those specific situations.
Does an administrative or executive body have the authority to narrow the scope of the statute?
That would
be a frightening thought.
Well, but we're talking about an entity that is quite different, and we're talking about narrowing the scope to protect Mr. Coe's First Amendment rights.
Well, what if the military decided that this statute was really getting in the way of efficient operations and just said, our policy is go for it. Do whatever you need to do. Just be a good soldier, be an effective soldier, and we don't care what you do. We don't care about discredit on the military. Times are tough. Could they couldn't institute a policy like that. There is a statute that prevents it, no?
Well, unfortunately, when we're talking about, let's just call it an executive branch agency, they make the decision what to enforce.
Executive branch agencies make enforcement decisions all the time, but they don't change the law. The law is what the legislature provides.
Right, but we're talking about something where we are talking about the most vague aspects of what might apply to a National Guard member. So
is that an argument for a court or a legislature? If the statute's too vague and all-encompassing, is that up to us?
Well, I think what I would say is you don't need to go there because, again, we're talking about Arizona policy, whether it's an absolute privilege or an intermediate or a qualified privilege. And I just wanted to give you the quote because I apologize I didn't have it earlier. It's Green Acres. It's the Arizona Supreme Court that said that the qualified immunity is for something that is an intermediate degree of importance. This court doesn't have to say, oh, because it's the military, therefore it must be absolutely privileged. And I would, again, urge this court to note that when we are talking, that the fact that a proceeding didn't take place is not relevant to what proceeding could have taken place. Absolute privilege has only applied when judicial functions are a guaranteed aspect of that proceeding. Here, we're talking about a motion to dismiss where the defense needs to be shown on the complaint, and we're throwing around all these questions of, well, maybe it was this, maybe it was this, and that's why it should be reversed.
Well, but the statute isn't conditional. The statute says shall be taken cognizance of by general, special, or summary court-martial, shall be punished at the discretion of the court. I agree it's broader than many people think about day to day, but it's there.
Yeah, and a summary court-martial we can get into again does not have many of the judicial functions required under Burns v. Davis. And I am going way over time, so if I'm trying your patience, I'll stop.
No, I've kept you over time, and I appreciate your sticking with us.
And we have one more question.
No, I appreciate it.
Can you remind me, did the HOA cite 261134 in its initial complaint?
No, it cited the non-existent DOD directive.
And do you think that was necessary?
What's that?
Was it necessary for the HOA, in your view, to cite the statute for absolute immunity to apply?
They needed to at least cite something that would be applicable to the public employee as a policy that might be enforceable for criminal punishment, because again, they're asking for absolute privilege. So a qualified privilege would still need a policy, it just might not be criminal. So either way, there had to be something. Otherwise, it's even more transparent of a hit letter.
All right.
Thank you.
Thank you, counsel. We thank you both for your arguments. This matter is now taken under advisement, and we will issue a written decision in due course. We are now going to take a brief recess to set up for the next oral argument. We're at recess.
Anyway, we'll talk.